Welcome to the top 10 things to know about wills, estates, and family trusts. My name is Charmaine Penko. I'm a collaboratively trained lawyer and mediator from Saskatoon, Saskatchewan, and I work with my team here at Penko Collaborative Law and Mediation. What happens if I die without a will is probably one of the top 10 questions that we get from time to time. And there is a bit of an urban legend out there that is not correct, where people assume if you die without a will, the government is going to take everything. Well, that's simply not true. Here in Saskatchewan, we have a piece of legislation called the Intestate Succession Act. And what it does is it lays out what will happen to your estate in the event that you have died without a will. If you die and you have left behind a spouse, then your estate is going to go to your spouse. If you also have children with your estate will still go to your spouse. The presumption there being your spouse is the one who is best situated to determine what the needs are of your children. If they're minor children, they have a responsibility to provide financially for them. If they're adult children, well, your surviving spouse may or may not decide to leave a gift under the terms of their own will. Of course, if they die without a will, the Intestate Succession Act will apply to them. And since you've predeceased them, it means that they're dying then with children, and the children are going to receive an equal share of the estate. Now, if you have died and you have a spouse, but you also had a previous relationship where you had children from that relationship, your current spouse is going to have to share the estate with the children that you've left behind from a previous relationship. Now, if you don't have a spouse and you don't have any children, then next in line are your parents, and the estate is to be shared equally between them. Maybe your parents have predeceased, then your estate would go to your brothers and sisters to be shared equally among them, using the phrase per stirrupies. Per stirrupies meaning that you're just continuing to follow the bloodline of the family tree in order to distribute the estate. Now remember, this is what kicks in if you don't have a will, which means it's important to have a will in place so that your actual wishes can be followed. Now, do you need a lawyer to write the will? The short answer is no, but of course, it's a good idea to retain a lawyer. If you can't meet with a lawyer right away, maybe you're watching this video and you're thinking to yourself, boy, I would want to make sure that my estate went to certain people, or perhaps you have a gift that you want to leave to a charity, then you can take a piece of paper right now and a pen and you can write out those wishes and you can date and sign that document. And here in Saskatchewan, that's called a holograph will, and it is considered valid and enforceable. Now, if you worked with a lawyer, though, a lawyer will walk you through some of the important questions for you to consider in putting together your instructions for your estate planning and your will in particular. For example, who would you like to name to be the executor? That's the person who is going to be making decisions and implementing your wishes under the terms of your will. You may have some special gifts, and determining how much to leave, and whether it's a dollar value or a percentage of your estate, and making sure that the charitable organization that you wish to leave your gift to is named properly. Or you might have gifts that you would like to leave to individuals. The rest of your estate, after all your debts have been paid and the expenses related to administering your estate have been dealt with, everything that's left over after the special gifts is what we call the residue. And a lawyer will ask you what your intentions are for that residue. Would you like to leave the entirety of that residue with your spouse? Would you like to share it amongst your children? A combination of those things. A lawyer is also going to check to make sure that you have provided for the people that are your dependents under the terms of your will. They will determine whether you have dependents, such as minor children, that maybe special provisions need to be included for them in your will, such as naming a guardian. Sometimes people want to know, how can I avoid probate? Now, probate's just a fancy word that means prove the will. So when you die, if you've left a holograph will, you'll remember that's the will that's in entirely in your own handwriting. Or if you've left a formal will, somebody has to take that will to the court and show that it is a legitimate will, that that is your handwriting, or that the requirements for a formal will have all been met, so that the court can give your executor or your administrator, if you've died without a will, a piece of paper that says, yes, this person's now authorized to deal with the estate. And that piece of paper is called letters probate. Now, the court will charge you a fee to issue that piece of paper, and not you directly, of course, because in this example, you've passed away, but your estate will be charged a fee, and that's what's called probate fees. And this is what people will often be trying to avoid when they say, how can I avoid probate? They want to protect their estate from having to pay a fee to the court. Now, there are ways to minimize what those fees would be. So, for example, sometimes people will put an asset in joint names with another individual, like your house. And when you pass away, then the other title holder has the right of joint survivorship, which means the title just automatically rolls over to be in their name. So the value of that asset then will not be subject to probate fees. However, sometimes you may have an asset that would attract capital gains taxation to the new owner, and that would be something to get tax advice about, to make sure that you aren't avoiding probate fees just to set your estate up or your beneficiary up for having some different fees that may be even more than what those probate fees might have been. There are other fees that the court will charge over and above probate, and that is a disbursement for just initially filing the court documents of $200. And keep in mind that court fees change from time to time, so depending on when you're watching this video, these numbers may not be accurate. You will request what's called a certificate of no infants for $25, and then if you're working with a lawyer, there is a tariff that allows your lawyer to charge a set amount based on the value of your estate for what they call core services. Now, if your will is very complicated or is disputed, the lawyer can then bill for that additional time as well. Now, there's an example here of how that would break down if we have somebody named Chris who has a $200,000 estate and they're using a lawyer. They're going to have probate fees, their court fee, their certificate fee, and then it's going to be a flat fee of $1,500 to the lawyer, plus an additional $2,000, because the lawyer can then charge 1% of the $200,000 value of the estate. So the total cost in that example would be $5,125. Now, if Chris's estate is actually $700,000, because let's say they have a house and it's in their name alone, whereas in the first example, perhaps they owned it jointly with their spouse, and they're using a lawyer, you can see the cost to probate the will be significantly higher because it's based on the value of the estate. This might be it may be preferable to try to not have the house included to reduce those fees, and it might make sense if you are owning your house with a spouse. But if you have added an adult child to title to your home, it might complicate things, because you will then no longer be able to make autonomous decisions connected to your house while you are still alive. So this is an example of a scenario where you would want to get not only good tax advice, but also legal advice. People often wonder what a family trust is. Now, this is a legal arrangement where there's a settlor, there may be more than one beneficiary, but a beneficiary is the person who's going to benefit from that trust, and a trustee, that's the person who's in charge of managing the trust and distributing it and making decisions about it. Now, it is a separate legal entity, so it gets taxed separately and it can be protected from creditors, and it can be expensive to set up. So where there is benefit, there is cost, and a family trust is not necessarily necessary in every situation. It's another example of where getting good legal advice as to whether it would be appropriate in your situation or not would be key. What if you have assets in other countries? So if your will is valid in one country, typically it's going to be valid in another country. But if you probate your will here in Saskatchewan and you have assets in Florida, then your will is going to have to be resealed, which simply means the court there also has to be convinced that it is a valid will. And they will rely on what the court in Saskatchewan did, but you'll have to prove what it was that the court in Saskatchewan looked at to determine the validity that they were able to then issue letters probate. So you might want to look at the option of having an international will drafted instead of just a regular will here in Saskatchewan. It's not particularly complicated. It's a good way of being able to minimize some of the administrative steps that your executor would have to engage in after you've passed away if you have property in other parts of the world. So things to think about. Where does your executor live? What will make it easy for them? Does your executor have all the information they need to locate your assets and pay your debts in whatever jurisdiction those may be in? And does your family know how you want to have your estate distributed? Have you talked to a lawyer in both countries, the country you're living in and the country where your assets are? And once again, have you received tax advice? Fifth out of our 10 commonly asked questions or things that are important to know about wills, estates, and family trusts is this. Can somebody challenge my will in court? Well, it kind of depends. A valid will is one where you had mental capacity and a full understanding of your assets and obligations. You haven't been pressured by somebody to do something that you don't want to do. And if it's a formal will, have the legal requirements under the legislation been met? Now, if somebody thinks your will is not valid, then they can bring a court application. If you're listening to this video and you are thinking about somebody who has passed away and you're not sure if their will was valid and you might be considering challenging it, consider talking to a lawyer who is collaboratively trained and possibly talking to a mediator. Because if you can work out the details of this dispute in a non-adversarial process, you typically will save time, you will save money, and you will be able to preserve the relationships. Number 6, do you need a power of attorney? Well, the short answer to this is a resounding yes. This is a document that not a lot of people talk about because people tend to be focusing on what they need to know about putting their last will and testament in place. But the power of attorney document is the one that people will rely on if something has happened to you and you've lost your mental capacity. So then if you've maybe had a car accident where you've suffered an injury that makes it you're unable to attend to your tasks like paying your bills, or you have early onset dementia, or something else that is compromising your ability to make good decisions about your property and your finances, the power of attorney document authorizes the person that you've named to be your attorney. Doesn't have to be a lawyer. This is just somebody who you trust and you believe has the skills necessary to manage your property and financial affairs. A healthcare directive is another document to put your mind to when estate planning. This is a legal document that gives somebody the authority to provide instructions to your medical care provider if you're unable to do so. And the person that you appoint is called your proxy. So some things to consider in putting into place in your healthcare directive is whether you want to have medical interventions if you are otherwise unable to sustain life without the interventions. Some people prefer to have all efforts made and others prefer to be left alone. Do you want to do not resuscitate if you have stopped breathing? Would you want the medical care professionals to do everything within their power to try to resuscitate you? And most importantly, have you talked to your family about your wishes so that it doesn't come as a surprise to them should they be asked to give directions to healthcare directive, or sorry, to the healthcare provider, the medical care provider, giving instructions to them that they feel very confident are aligned with your closely held values and beliefs and your wishes. Communication overall is key. Talking about these topics is very uncomfortable. However, if something happens to you, the people who love you are no longer going to have access to you to find out what your wishes are or to clarify them. Conflict will arise when you have more than one person that cares about you in your family system or your friend group that have different interpretations of what your wishes are. So meeting with a third party like a mediator, somebody who's neutral that can facilitate the conversation so that it can be more comfortable for you to lay out what your wishes are, but also to talk to the people that you love to better understand what some of their expectations might be so that in the end result of how your estate is managed, whether that is while you are still alive but unable to make decisions for yourself or upon your passing, then everybody can have their interests aligned and feel more comfortable in implementing what your desires are. Complex situations arise more often than you can imagine, and it's the stuff that makes up for entertaining reading for law students in law school. And you really hope that your matter will never show up there. Succession planning is important for everybody, but if you own multiple properties or businesses, or you are a beneficiary or going through a separation and divorce, maybe you have a blended family, or you have somebody in your family who's a dependent with special needs. These are all examples of complex situations where getting good advice and putting your mind to your planning well in advance is crucial. It's important for you to design a structure for your assets, one that will minimize your taxes, will streamline the transfer of ownership, and will protect your hard worked for assets from claims by third parties. And finally, you've heard me say it multiple times throughout this video, seek expert advice. If you do decide to draft your own documents, you might benefit from having them reviewed by a lawyer. There might be things that you haven't even considered that an expert could bring to your attention. People that could help you with this include accountants, financial planners, lawyers, and mediators, somebody who can sit down with you and your spouse or other family members or friends to be able to talk through these difficult issues, identify where additional information might be helpful to gather so that your plan is one that is sound in every direction. Thank you for taking the time to watch this video. If you have further questions, please don't hesitate to reach out. You can contact me directly, Charmaine Penko, by email, cpenko@commonsenselawyer.com. But you could also reach out to anybody at my team and call us. 306 is our area code, 975-7151. Also invite you to visit our website, www.commonsenselawyer.com, to meet the other members members of our team. Wish you the best in your succession planning and putting together that last will and testament, your power of attorney document, your healthcare directive, possibly even a family trust.